Good morning, everyone. I'd like to welcome everyone to the 13th meeting of the Public Utility Commission for calendar year 2014 and ask that you join us in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first matter on this morning's agenda is the approval of the minutes of the June 19th meeting. It's a pleasure to welcome Commissioner Whitmer as the editor of the minutes. Commissioner Whitmer.
Thank you, Mr. Chairman. I have reviewed the minutes of the June 19th public meeting, and Joni Mitchell and I are pleased to state for the record that Paradise has not been paved over to put up a parking lot, and therefore move that the minutes be approved as submitted.
Second. Any discussion? Any objections? The minutes are approved as submitted, and it's a pleasure to welcome to the podium to begin public meeting Ms. Cheryl Walker Davis. Good morning, Cheryl.
Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
Good morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items. Commencing this morning with matters on behalf of the Bureau of Administration, it is recommended that the commission adopt the recommendation to approve the Evaluation Committee's choice to enter into final contract negotiations with regard to the stratified management and operations audit involving Philadelphia Gas Works.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 2 of the public meeting agenda, on behalf of the Bureau of Audits, it is recommended that the commission adopt the two recommendations there with regard to the release of audit reports involving Walker Gas and Clarion River Gas, Section 1307E, matters statements.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 3 of the public meeting agenda, with regard to the Office of Competitive Market Oversight, it is recommended that the commission adopt the recommendation there appearing to reduce the amount of bonding or security that electric generation suppliers must post after their initial year of operation, as well as expanding the types of security instruments that can be used to satisfy that obligation.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters on behalf of the Office of Special Assistance, commencing on page 4, it is recommended that the commission adopt the first recommendation with regard to the long-term infrastructure improvement plan and the distribution system improvement charge involving Little Washington Water Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the next item, which pertains to the joint petition of Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company, and their default service programs, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. I will submit my comments for the record, but I will summarize them. Before us today is the joint petition of the First Energy Companies for their default service programs. On March 27th of 2012, the parties to this proceeding filed a partial settlement. The parties failed to settle on terms for one specific issue. This issue relates to whether the First Energy Company should assume responsibility for PGM's network integration transmission surcharge for all customer load. On May 6, 2014, the ALJ issued a recommended decision which recommended approval of the partial settlement without modification and denied the proposal by RESA and First Energy Solutions to incorporate the surcharge into the company's rider. In the recommended decision, the ALJ correctly determined that the surcharge can reasonably be included in the default service supplier rider, that the circumstances have changed since the company's last default service program that warrant a reevaluation of this issue, that it is appropriate for the surcharge to be assessed on a competitively neutral basis, and that there is sufficient lead time until the implementation of the instant programs to permit, if necessary, the renegotiation of contracts to mitigate any potential double billing. However, the ALJ ultimately recommended maintaining the status quo determined in the company's last default service plan and not incorporating the surcharge into the rider. First, let me state that I believe each of the issues that were successfully settled by the parties work to create a default service plan that satisfies the requirements of the Public Utility Code. However, it is my opinion that the collection of the surcharge in a competitively neutral manner can work to benefit consumers by reducing the risk premiums that EGSs and wholesale generation providers embedded in their prices. The concept is similar to the reasons why regional transmission expansion plan and generation deactivation costs are also prudently recovered in this manner. As such, I will vote to approve the default service plans, but note my partial dissent or concern with the network integration transmission surcharge issue.
Thank you, Commissioner Brown. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting Commissioner Brown's statement.
In omnibus fashion, we recommend the adoption of the OSA items commencing with Chenevelin Samuel versus Pico Electric at the top of page 3 and continuing with the remaining item on page 3, as well as all items appearing on page 6. I'm sorry, that was page 5, not page 3. As well as the items appearing on page 6 and the first 2 items through and including the interconnection agreement of Verizon North LLC and Business Automation Technologies, Inc., DBA Data Network Solutions on page 7.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the OSA recommendation with regard to the next 3 interconnection agreements. Those pertain to Verizon North LLC and Megapath Corporation, Verizon North LLC and Cellco Partnership DBA Verizon Wireless, and a second one involving Verizon North LLC, DBA Cellco Partnership DBA Verizon Wireless, noting the statement of Commissioner Brown, the combined statement with regard to all 3 of those matters.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her combined statement. Commissioner Brown.
Thank you. We have before us several interconnection agreements executed between an incumbent local exchange provider and competitive local exchange providers or affiliates of the incumbent that are wireless providers. The agreements were effective over a decade ago, but were not filed with the Commission until this year in response to our order of November 14th of 2013. We directed the incumbent to review all of its interconnection agreements and to file any interconnection agreements not approved by the Commission. Section 252E of the Federal Act requires providers to file these agreements. The Commission then reviews and acts on these agreements within 90 days or they are deemed approved. The Commission can reject or amend agreements if they are discriminatory or not in the public interest. These agreements must be made available to other competitors under the pick and choose rule. I certainly appreciate that there may be an occasional lapse in filing these agreements due to institutional considerations. I also commend the carrier for heeding our direction back in November to conduct the required review and file these agreements. That being said, I would be remiss if I did not reiterate my concerns, as I did last meeting, regarding the 10-year delay in filing for the majority of these agreements. That is 10 years during which competitors could not opt into the agreements. In the future, I would not hesitate to recommend to my fellow commissioners that such an unexplained filing delay be subject to further examination, including possible referral to the Commission's Bureau of Investigation and Enforcement for action as they deem appropriate.
Any objections?
Mr. Chairman, I'd like to associate myself with that statement.
So noted from Commissioner Whitmer. Any further discussion? We have no objections. The motion passes unanimously.
Continuing with the presentation of public meeting agenda items and matters on behalf of the Bureau of Technical Utility Services, it is recommended that the Commission adopt the items commencing with the letter petition of PPL Electric Utilities Corporation with regard to appointments to the Sustainable Energy Fund Board of Directors at the top of page 9, and continuing with all matters on pages 9, 10, 11, 12, 13, 14, and the first 4 items on page 15 through and including the rate increase request of Gardner Moving Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt the Bureau's recommendation to make the earnings report, the quarterly earnings report for the first quarter of 2014, available to the public.
So moved.
Second.
Any discussion?
Chairman, I respectfully wish to be recorded as voting no. It's not the release to the public, it's the percentage allowed or the rate allowed that I disagree with. Thank you.
So noted, Commissioner Cawley. Any further discussion? We have the objection noted of Commissioner Cawley. The motion passes 4-1.
Turning now to matters presented on behalf of the Law Bureau, it is recommended that the Commission adopt the first recommendation with regard to the tentative order involving Earnest Communications, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt the Bureau's recommendation in the investigation involving the practice of paper invoice charges, noting your statement, Mr. Chairman, as well as the statement of Vice Chairman Coleman.
So moved.
Second.
I simply want to add into the record here today just a quick conflict statement. Prior to joining my staff, Norman Kennard served as counsel for two of the parties in the above proceeding. Therefore, to avoid any impropriety arising from his previous employment, I have not been advised by Norman Kennard regarding this matter. And I'd like to recognize Vice Chairman Coleman for purposes of his statement. Vice Chairman Coleman.
Thank you, Chairman. I would just ask that my statement be entered into the record as though I read it in its entirety. Thank you.
Thank you. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting my conflict statement and along with the statement issued by Vice Chairman Coleman.
It is recommended that the Commission adopt the Law Bureau's recommendation in the proceeding involving Skytop Large, Inc.'s petition for declaratory order, noting the statement of Commissioner Cawley as well as the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Thank you, Chairman. I respectfully wish to be recorded as a no vote. Not that the position that has been recommended to us is an unreasonable one. I simply think that we should refer this matter to the Office of Administrative Law Judge to examine the relationship of the 74 property owners who actually own properties at this resort and their relationship with the resort itself. I think if we did further fact-finding, we would come to a different conclusion here. And that would be simply that this is a very confined group of people completely within a resort area who have, I think, a defined privileged relationship with the resort. And I would not find that this is a public utility, at least under the facts. But I'm not sure that we have all the facts, and that's why I respectfully dissent.
Thank you, Commissioner Cawley. Now I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you. Let me first say I can understand Commissioner Cawley's concerns. I would love to have had more facts on this case as well. That being said, I will be voting to support this matter. Based upon the information that Skytop provided to the Commission in their petition, I have to agree with Law Bureau's determination that Skytop does fall under the definition of a public utility as defined under the Public Utility Code. This determination is based upon case law and Commission precedent. It reflects information found in the deeds contained in the record which permit the sale of properties to buyers over whom the corporation would have no control. In addition, these properties are not under the jurisdiction of a homeowners association, which would have removed Skytop from the definition of a public utility. I sympathize with the business entity and the next steps that they will have to take to be in compliance with the law. This proceeding truly accentuates my concern that there may be other similarly situated companies operating operating as unregulated entities because they do not have a full understanding of what the law requires, and they believe that they can operate similar to a municipality that's providing water service to citizens within their jurisdictional boundaries, when in fact they're really subject to our jurisdiction. In this case, the regulatory oversight is required under the Public Utility Code and necessary to provide quality service and essential customer protections. I do encourage our commission staff to be proactive in working with DEP to educate similarly situated entities as to the statutory requirements under our law. Thank you.
Thank you, Commissioner Brown. I just want to note for the record, we want to enter into the record Commissioner Cawley's statement. I don't think I noted that. And I'd simply just, before we conclude this case, mention that during the course of the proceedings involving this matter, the company was, for lack of a better word, not very forthcoming with information that was needed in making this determination whether it was a public utility or not, and numerous extensions had been provided to the entity. So I think we are in a good spot here this morning in the decision that we make. And to pick up on Commissioner Brown's point about the number of entities that might be out there in the marketplace that fit into this issue of whether they're public utility or not, I think this commission, dating back to 2008, has done a remarkable job on the environmental side, working with the Department of Environmental Protection, taking distressed water systems and moving them into a more regulated framework. But I do recognize, Commissioner Brown, your concern here this morning and noted in the record. Is there any further discussion regarding this case?
Chairman, I forgot to mention that I too would like to submit my comments for the record.
So noted. Hearing no further discussion, we'll note the objection of Commissioner Cawley, and the motion passes 4-1.
Turning now to matters presented on behalf of the Office of Administrative Law Judge, it is recommended that the Commission adopt the two items appearing on page 17 as well as the first matter, that being Philadelphia Gas Works petition for special permission, appearing at the top of page 18.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of Judge Buckley's initial decision in the proceeding involving Habana Holding Corporation versus Philadelphia Gas Works, noting the joint statement of Commissioner Cawley and Commissioner Brown.
So moved.
Second.
Like to recognize Commissioner Cawley for purposes of the joint statement with Commissioner Brown. Commissioner Cawley, or excuse me, Commissioner Brown will be reading. I'm sorry.
I have a lot to say today, obviously. On behalf of Commissioner Cawley and myself, I'd like to offer this joint statement. On March 24th of this year, Habana Holding Corporation filed a complaint alleging that all past due balances for its natural gas service at its rental property had been paid in full, that liens placed against the property should be removed, and that it was told that a PGW supervisor would call to discuss the account, but never did. On April 23rd of 2013, PGW filed preliminary objections, averring that the Commission lacks jurisdiction over the subject matter of the complaint. The ALJ held that the complainant must obtain relief through the procedures established by the municipal claim and tax lien law. The ALJ granted the preliminary objection based on a lack of Commission jurisdiction and dismissed the complaint without hearing. For purposes of disposing of a preliminary objection, the Commission must accept as true all well-pleaded material facts of the non-moving party, as well as every reasonable inference from those facts. The complainant in this case shows that in addition to asking that the liens be removed, which we agree is outside of our jurisdiction, they allege incorrect billing and that PGW's customer service was not satisfactory. Both of these issues fall within the Commission's jurisdiction under Section 1501 of our code. Accepting these allegations as true, the complaint here does raise violations which we have the jurisdiction to hear under the Public Utility Code. As such, the matter did not meet the standard for granting a preliminary objection and should have proceeded to evidentiary hearing. Accordingly, we respectfully dissent from the initial decision of the ALJ.
Thank you, Commissioner Brown. Any further discussion? We'll note the objections of Commissioner Cawley and Commissioner Brown, and the motion passes 3-2.
That concludes the presentation of regular agenda items. Turning now to the carry-in agenda. With regard to matters on behalf of the Office of Special Assistance, we will take the first two items in tandem, those being the petitions of the Bureau of Investigation and Enforcement for interim emergency orders requiring Uber and Lyft to cease and desist the provisioning of brokerage transportation services for compensation between points in the Commonwealth of Pennsylvania. We recommend the adoption of the staff recommendations there, noting the statements of Commissioners, Vice Chairman Cawley and Commissioner Cawley, the combined statements applicable to both of those items.
So moved.
Second?
For the record, it's Vice Chairman Coleman
Oh,
and Commissioner Cawley.
that's why he was
I am
smiling.
paying attention here this morning. We're a little role reversal, but we're going to start with the Vice Chairman for purposes of his statement here this morning. Vice Chairman Coleman.
Thank you, Chairman, and thank you for the clarification. I'd ask that my statement be entered into the record for both cases as though I read it in its entirety. I'm in full agreement with the orders of interim emergency relief and the staff recommendations that we adopt them. I'm very disappointed that the Bureau found it necessary to seek this relief due to the applicant's apparent unwillingness to delay offering service for compensation while their applications were pending. The Commission has been charged with the affirmative obligation to protect the public by enforcing the provisions of the Public Utility Code. While the Commission has expressed support for legislative reform on the subject of transportation network companies, no bill has yet been signed into law. Until that happens, the Commission and its enforcement staff remain obligated to enforce the law as it is, not as how we would like it to be. I will conclude by thanking our Motor Carrier Enforcement Manager, Charlie Bowser, and the prosecutors of our Bureau of Investigation and Enforcement for their diligence and commitment to ensuring the safety of the public. Their investigation and enforcement activities in these matters are keeping with the highest tradition of the Commission, and they should be commended. Thank you, Mr. Chairman.
Thank you, Vice Chairman. Now I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Thank you, Chairman. I wish to associate myself with the Vice Chairman's entire statement. And I also ask that that mine be included in the record. I'm going to read all of it, so there won't be any necessity to incorporate it by reference. Before the Commission are petitions of the Bureau of Investigation and Enforcement for interim emergency orders requiring Uber Technologies, Inc. and Lyft Incorporated to cease and desist from brokering transportation service for compensation between points within the state without a certificate of public convenience from the Commission. These are two of a number of cases relating to the activities of Lyft and Uber, including Uber's subsidiaries, that are before the Commission. In order to aid in the formulation of a final order in these proceedings, I will request by subsequent secretarial letter, as our regulations provide, that Uber and Lyft provide the number of transactions or rides provided to passengers in Pennsylvania via the connections made to drivers through the internet, mobile application, or digital software during the following periods. A, from the initiation of such service in Pennsylvania to the date on which complaints were first filed by the Commission's Bureau of Investigation and Enforcement against Uber and Lyft drivers. B, from the date that the same complaints were filed to the date on which a cease and desist order was entered against Uber and Lyft. And C, from the date of entry of the cease and desist order to the date on which the record in these proceedings are closed. The parties should address the issue further of whether, should there be a finding that Uber's and Lyft's conduct in any one or all of the above periods was a violation of the Public Utility Code, refunds or credits to customers would be an appropriate remedy. And secondly, the parties should also address this issue, whether either evidence of prior unlawful operations or contumacious refusal to obey Commission orders negates the need for the proposed service and/or the fitness of the applicant as a common carrier, such that no certificate of public convenience can be issued by the Commission. Thank you, Chairman.
Thank you, Commissioner Cawley. Any further discussion?
Mr. Chairman,
Commissioner Whitmer.
regarding the vote, I am concurring in result only. I am supporting the majority in the result only on the cease and desist order for both Razor and Uber for both of these cases, because I do not think that the Bureau of Investigation and Enforcement has proven that a right to relief is clear as outlined in 52 of the PA Code, Section 3.6B1, that Razor and Lyft are a broker.
Thank you, Commissioner Whitmer. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the combined statements of Vice Chairman Coleman and Commissioner Cawley, and we'll note here this morning that Commissioner Whitmer is going to concur and result only on both combined cases.
Turning now to the next item on page 2 of the carry-on agenda, we recommend the adoption of OSA's recommendation with regard to the Razor PA LLC petition for interlocutory review and answer to material question with regard to the standing of a limousine provider or a taxi cab company to protest the existing applications.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Once again, we will present the next 2 items in tandem, those being, we recommend the adoption of the staff recommendations in the proceedings involving the applications of for emergency temporary authority for Razor PA LLC and Lyft Inc., noting the combined statement of you, Mr. Chairman, and Commissioner Whitmer, the combined statement of Vice Chairman Coleman, the combined statement of Commissioner Cawley, and the combined statement of Commissioner Brown with regard to both items.
And just for the record, I want it to be known, since being a commissioner for 6 years now, I think this is the first time ever all 5 of us had a statement on a case. So this must be a big deal. And with that, we'll start with Vice Chairman Coleman.
Thank you, Mr. Chairman. I would ask that my statement be entered into the record for both cases as though I had read it in its entirety. I agree that there is an immediate transportation need for applicants' experimental ride services. Moreover, their services have the potential to provide substantial benefit to consumers in Allegheny County in the form of another competitive alternative to traditional call and demand service. At the same time, our decision maintains adequate safeguards to protect the safety of the traveling public during the pendency of the ETAs. These safeguards include requiring the vehicles operate as part of the service to be responsible for compliance with the Commission's vehicle safety requirements. These safeguards also include ensuring that the vehicles operated as part of the service have adequate insurance coverage during the pendency of the ETAs. However, I am troubled by the allegations of unauthorized service made by the Commission's Bureau of Investigation and Enforcement and the ongoing compliance proceedings against Razor's corporate parent and against Lyft. Our decision to grant ETA has no bearing on the final disposition of Razor's application for permanent authority to provide ride-sharing services or in the ongoing compliance proceedings against Uber. The same holds true for Lyft's application for permanent authority and the ongoing compliance proceedings against it. If BI&E finds that the burden of proof in these other proceedings that Uber and/or Lyft have provided unauthorized service, Uber and/or Lyft may be subject to civil penalties under the Pennsylvania Public Utility Code, and the rates charged for the unauthorized service may be subject to refund. Thank you, Mr. Chairman.
Thank you, Vice Chairman. Now I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Thank you, Chairman. Again, I associate myself with the Vice Chairman's entire statement. Before us are 2 orders granting emergency temporary authority for experimental service. It's important to remember that the principal reason that the Public Utility Commission has jurisdiction over taxi cabs or taxi cab-like service is protection of the public safety. Without that, we wouldn't have jurisdiction at all. So we ask ourselves on a constant basis, is the vehicle safe? Is the driver a responsible operator and a law-abiding citizen? Is there adequate automobile liability insurance in place if personal injury or property damage occurs? Razor, Uber, and Lyft promised to improve upon the current taxicab model with application-based services. Independent contractor drivers using their own vehicles, covered by their own personal automobile insurance policies, provide the service. Unfortunately, there are a number of problems under current law with that business plan. And Uber and Lyft were both told that by our commission lawyers months ago, and the need for legislative changes before they operated in Pennsylvania. Both companies have chosen to ignore that advice. The orders today confirm if emergency temporary authority under, quote, experimental service is to be granted, that this commission will insist that the public safety be preserved. We have ordered improvements in the required insurance by making both Razor and Lyft have the primary, not the excess, responsibility for insurance coverage. That is extremely, extremely important. We've also, as an accommodation, reduced the maximum age of the vehicles that can be used to provide service by these drivers. These changes will benefit the operators, passengers, and the public. With these changes, I can support granting temporary authority, but whether either of these carriers deserves a permanent certificate of public convenience, and if so, under what conditions, remains to be seen. I also support temporary authority out of my respect for the efforts of certain legislators, chiefly Senator Wayne Fontana, to amend the law to provide for, quote, transportation network companies, unquote, with public protections absent from the present service provided by both Uber, or Razor, and Lyft. Finally, my thanks go out to the staff members of the various commission bureaus who have worked diligently to serve the public interest, despite adverse comments from public officials, the media, and the applicants regarding our insistence that the law be obeyed. Thank you, Chairman.
Thank you, Commissioner Cawley. That pregnant pause got me a little nervous. I want to now recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. I ask that my statements also be entered into the record, but I would like to summarize them. I'm voting to approve Razor or Uber and Lyft's emergency temporary authority application because I believe that the companies have met the standard established under our regulations stating the grant of temporary authority or emergency temporary authority, and that it provides for an immediate need. I know that in their applications, they have provided statements from many Pittsburgh area residents regarding the immediate need for an alternative mode of transportation in Allegheny County. I do want to note that approval of these applications is solely for emergency temporary authority, but I do look forward to reviewing a fully developed evidentiary record regarding the company's applications for permanent authority in the near future. Thank you.
Thank you, Commissioner Brown. Now I'd like to recognize Commissioner Whitmer for purposes of a joint statement with myself. Commissioner Whitmer.
Thank you, Mr. Chairman. I'd like our joint statement entered into the record as if I had read it in its entirety. As has been stated here today, before the Commission are the applications of Lyft and Razor, a wholly owned subsidiary of Uber Technologies, for emergency temporary authority to operate an experimental transportation network service in Allegheny County. These proposals, although temporary in nature, foster the ability for Allegheny County residents to avail themselves of regulated transportation service that uses modern technology to serve traveling customers in that county. As evidenced by our action today, the Commission strives to ensure that its current regulatory structure is not a barrier to technological advances and desirable changes in the transportation industry. Similar to statements we've previously made regarding an earlier application for experimental service in Allegheny County, we agree with today's findings that there will be an immediate and substantial benefit derived from the initiation of this competitive transportation service. The introduction of these app-based transportation services in Allegheny County will provide customers with competitive alternatives to traditional call and demand service that can provide wider-ranging, faster, and more user-friendly scheduling of transportation services. Just as important, both Riser and Lyft have committed to full compliance with our public safety regulations regarding driver integrity, vehicle safety, and insurance. These attributes are vitally important because as the agency charged with regulating motor carrier passenger transportation in the Commonwealth, this Commission has a responsibility to protect the safety of the traveling public. This is why we are especially pleased with the commitments of both Lyft and Riser to substantially exceed our current insurance requirements. As we have stated during proceedings involving other types of industries, it is appropriate for the Commission to periodically review its regulations to determine whether or not they have kept pace with current industry standards and practices. Transportation is no different, and therefore we look forward to exploring the adequacy of our current provisions of our transportation regulations, including insurance requirements, the necessity for geographic territories, driver integrity standards, and vehicle safety standards, as well as other issues during our upcoming en banc hearing on August 28th. Likewise, we are supportive of working with the General Assembly to craft legislation that could provide another option, which transportation network companies will allow them to operate legally in Pennsylvania. And as I noted, this is a joint statement, but I have to say for myself, Mr. Chairman, I'm especially pleased to support the ETAs for Riser and Lyft so that Pirates, Penguins, and Steeler fans can get to and from PNC Park, Heinz Field, and Consol Center safely. Thank you.
Thank you. I guess they're not coming down the turnpike to an Eagles game. Is that what I heard you say?
Only to win.
Okay. Well, let me first start off.
You started.
I did start it, and I'll end it with some brief comments. I don't know. Am I allowed to associate myself with every statement that was made on this matter? Because I'd like to do that. And let me first start by saying, I'm going to be brief here. In my view, the application approval here today for both of these entities represents, I would like to say, real progress, but I think Commissioner Cawley and the Vice Chairman and all of my colleagues mentioned the work that's being done by Senator Wayne Fontana from Allegheny County. And I want to say the Senator has been extremely proactive in his outreach with the Commission, and I think he's to be commended. He's doing this in a bipartisan way. He's very cognizant of some of the, quote, idiosyncrasies in our transportation laws. And I think what he's trying to do is encourage these companies to operate legally in the Commonwealth of Pennsylvania. Now, given the public reaction, and I want to make it very clear, I appreciate every resident of Pittsburgh that sent an email, a letter to this agency, because we heard you loud and clear here this morning. And we recognize that passengers across the Commonwealth, and in particular in Allegheny County, have made it known that they want alternatives to traditional monopoly taxi cab service. I don't know how many times I read emails where consumers were not pleased with the incumbent taxi cab service that they are being provided in that particular part of the state. But, and I use but here because I think the Vice Chairman honed in on this, and as well as Commissioner Cawley, we are not going to cut corners on safety and the responsibilities that we have been tasked with in the Public Utility Code to make sure when a passenger gets in a vehicle and they go from point A to point B, that that passenger has the peace of mind that that vehicle is properly inspected, it has proper lines of insurance, and that that vehicle going forward is agreeing to be inspected by a transportation safety officer at the Commission. We can't have the wild, wild west in the transportation sector here in the Commonwealth of Pennsylvania, and I think we all agree to that. So I'm pleased to say that the applications before us today have agreed to meet these obligations, and those obligations are very straightforward. The requirements around driver integrity, vehicle safety, and insurance. I think it's also a very critical piece to the puzzle going forward that we're offering this temporary emergency service, and I'm going to go back to some of the past sins of these entities where you were advised back in March to follow certain protocols established by the Commission and you opted not to. Today, you're getting a chance to take the midterm exam over by 5 of us agreeing unanimously to support this application for temporary emergency service. I don't expect any thank you notes from these entities. What I expect you to do is work with our Bureau of Transportation Safety and get yourself compliant so you can do business here in the Commonwealth of Pennsylvania. Again, I want to commend our Bureau of Transportation Safety, our Law Bureau in particular. I want to thank our Chief Counsel, Buck Pankew, who probably has gotten many gray hairs over the last 3 months in dealing with this issue. And I want to say this, again, the Commission looks forward to working with the legislature in a bipartisan way on how to deal with these new transportation service providers, these transportation network companies, as they're commonly referred to get them up and running here in the Commonwealth. Because I'll be very honest with you. These entities, it's Philadelphia, Pittsburgh, but mark my words, it'll be State College, Westchester, Pennsylvania, and many other communities across Pennsylvania where these alternative transportation sources are coming into the marketplace. So as a commission, we recognize it. We want to embrace the technology. This commission is, more recently, we received an innovation award. We're all about innovation, but you don't sacrifice innovation for safety. And that's, unfortunately, we took a lot of hits in the media, which I scratch my head at times to Commissioner Cawley's point that what we're tasked to do as an agency to protect consumers, and here we were trying to do our jobs and we got criticized as being loggerheads for not recognizing innovation. I find that a little bit offensive, but I'm always a reminder from my mother, my glass is always half full, and I believe that at the end of the day, as a result of today's actions, that the Commission should receive the benefit of the doubt in the public opinion polls that we are doing the right thing on behalf of the citizens of Pennsylvania to get this equation right, as I call it, to get these providers up and running legitimately. So I look forward to working with the General Assembly. I look forward to working with people like Mayor Nutter and Mayor Peduto who are passionate about bringing these new providers into their marketplace. And again, although we don't regulate Uber and Lyft in Philadelphia, I want to make that footnote here. I don't want to extend our reach. We have everything west of Philadelphia, I'm sorry. Again, I want to note here today that we are embracing these innovations in transportation service, but this is a work in progress. And again, I want to commend my colleagues for their statements here this morning. We stand unified in working together to really get these companies up and running. And with that, I will call the vote. Are there any objections to the 2 applications in front of us here today? Hearing none, the motion passes unanimously, noting the statements of all 5 commissioners here this morning.
Mr. Chairman, that does conclude the presentation of agenda items.
Before we adjourn, I want to recognize we have a couple items. One is Korea Williams is leaving us to go to the Sunshine State. And she has always been helpful to me working with Cheryl in preparation for public meeting. I just want to remind everybody today from 2 to 3 in the OCA conference room, we'll have a send-off. Now, I looked at the brochure here. Goodbye, we'll miss you. And then you put the license plate of Florida. But Korea, thank you for all that you've done. You've always come into my office when things were kind of heated at times, and you always have a smile on your face. And I just want to say thank you on behalf of all of us here for the great work that you did at the Commission. You're going to do great work in the state of Florida. Our loss will be the Sunshine State's gain. And I just want to congratulate you for a great tour of duty here at the Public Commission. Congratulations. And Cheryl reminded me, I had the opportunity to meet Emma O'Kell, who is a junior at Gettysburg College. She's been visiting the commission for the past week as part of the Gettysburg College Center for Career Development externship program. And Emma is majoring in environmental science and has been shadowing with Cheryl for the past weeks. I'm a little nervous that Cheryl might be corrupting her a little bit. I also reminded Cheryl, I know she's a proud Gettysburg College, but you could always get a St. Joe's or a Penn State student. No, I'm just kidding, Cheryl. But I recognize, and a Pitt. Yeah, I heard that, Commissioner Brown. But I want to commend Cheryl for taking that give back to your alma mater, and I know you've been doing this since I've been here. And Emma, I hope you've had a great week here at the commission. And where's welcome. We're going to adjourn, but I had asked everybody to please be seated because the main show is about to begin here in about 2 minutes. We are adjourned.